Thank you. Be seated. Good morning.
Good morning.
Yes, sir, Mr. Waters.
Your Honor, we are here today on the case of the state versus Richard Alex Murdaugh. He has been indicted by the Colleton County Grand Jury on July 14th, 2022 for 4 charges. Those charges are 2022 GS 15-592. That charge is for the murder of Maggie Murdaugh. 2022 GS 15-593. That is for the murder of Paul Murdaugh. 2022 GS 15-594. That is possession of a firearm during commission of a violent crime for the murder of Maggie Murdaugh with a rifle. And 2022 GS 15-595, that is possession of a firearm during commission of a violent crime for the murder of Paul Murdaugh with a shotgun. Your Honor, I am right now serving a copy of the indictment on defense counsel. Obviously, Mr. Murdaugh is present in court and represented by his counsel, Dick Harpootlian and Jim Griffin. Your Honor, it's my understanding at this time that the defense would request a formal arraignment. So we need to conduct that procedure at this time, Your Honor.
Yeah. Mr. Harpootlian, is that right?
Yes, Your Honor. That's fine. Your Honor, it's my understanding that they do want the formal arraignment but are waiving reading of the indictments. That's correct, Your Honor.
All right.
Richard Alex Murdaugh, if that is your name, please raise your right hand. Do you waive reading of the indictments?
Yes, sir.
What say you, Richard Alex Murdaugh? Are you guilty or not guilty of the felonies wherein you stand indicted?
Not guilty.
How shall you be tried?
By God and my country.
Thank you.
He's been so arraigned.
Thank you, Your Honor. Very quickly, as we move forward, the first thing I need to point out is that Attorney General Alan Wilson, of course, has been very involved from the beginning of this case, providing leadership on this case. He's currently traveling today and understands, though, the need to get this done, and so has permitted me and Mr. Zelenka to proceed with this matter. Also, very quickly, want to thank my SLED agents. We have Special Agent Dave Owen present, who's been one of the lead case agents on this. And I want to commend them on the long and arduous investigation over 13 months in which every possibility was considered before the evidence, as we explored every possibility, all came back to one person, and that is Alex Murdaugh. I'm happy to detail some. However, the defense has advised me that they are willing to consent to a no bond. So I will leave that to Your Honor's discretion, whether you wish me to go into some of the facts or if that take care of that matter. Once we get through bond, I do know that the defense and the state wish to discuss a few motions at this time as well, Your Honor.
Please report, Your Honor.
Yes, sir, Mr. Harpootlian.
Your Honor, we're consenting to no bond. He's, as you know, already has a $7 million bond he can't make. The further discussion of the alleged facts in this case in an open courtroom, we think continues to run the risk of polluting the jury pool, which in a moment I think we can talk about a speedy trial in this matter, which will occur in this courtroom. So we don't believe there's any reason to go into factual background. He's agreeing to no bond, and so we can move into the more procedural motions that we have. And I think we actually worked out an agreement on all the motions. So if we could do that, Your Honor.
Yes, sir.
Your Honor, beg the portion to open.
And Your Honor, very quickly, I'm going to just add that we have, of course, consulted with the victims in this matter. Our victim advocate is present, and some of the victims, as my understanding, are joining through the remote procedure. I just wanted to make sure that was on the record. Well, Your Honor, there's a few motions I know that Mr. Harpootlian and I have discussed. One of the first motions that has been discussed is a gag order. The state has no objection to a gag order. Mr. Harpootlian discussed it with me, and we do agree that that would be appropriate in this matter given the amount of media attention. This case, as I've been saying all along at various bond hearings along the way, needs to be tried in the courtroom, and so the state has no objection to that.
Your Honor, in addition to that, I believe we have an agreement that all discovery material furnished to us will be, even though this is not a statewide grand jury case, to be subject to a confidentiality order, the same confidentiality order that they use in statewide grand jury cases. Am I correct about that?
Well, yes, Your Honor, and another aspect, while that would be appropriate, is much of the information that's been gathered in the statewide grand jury case, all of the 81 allegations of white-collar fraud and other crimes, drugs and the like that's been gathered against Mr. Murdaugh over the course of that long investigation. A lot of that provides the background and the motive for what happened on June 7th, 2021. So that evidence blends together, and it would be appropriate for there to be a global protective order protecting everything related to this case.
Secondly, we propose that all motions in this matter, either filed by the state or by us, be sealed and subject to a motion by either party to unseal it. But that rather, again, I mean, we're put in a position of filing a motion on discovery to discuss what we've been given and what we haven't been given. And again, this is going to force us to disclose matters to the general public that we don't really want to discuss in public, because we're trying to get a fair trial for our client, not try it in the media, but try it in this courtroom. And I believe Mr. Waters agrees with that.
Your Honor, as long as there's obviously the opportunity upon appropriate showing for motions to be made public and for hearings to be public, then I think that is appropriate. I think we're not talking about hearings, we're talking about motions.
Correct. And hearings, to the extent that if there's something that needs, we can obviously discuss things in writing, submit them to Your Honor prior to a hearing, and not have those matters necessarily put on the record. But that's something down the line. So, Your Honor, we have an agreement as to confidentiality. We have an agreement as to filing matters under seal. And I think that takes care of that issue. Is that correct?
Obviously, it's the judge's decision, but I believe we are in general agreement on those matters.
Your Honor, could I
Yes, sir.
move on to the next matter?
Well, let's address the matters thus far. Regarding a gag order, what's your understanding as to the parameters of a gag order, which is I typically disfavor? What's your understanding as to the parameters of a gag order?
Well, I think, in Your Honor, it would need to be somewhat limited. I think that obviously there needs to be the ability to advise the public of upcoming hearings. Obviously, we've talked about the ability to advise or to move to unseal motions. But I do think that extrajudicial comments to the press would be the limits of what I see, but that obviously any sort of, aside from notice and that sort of thing, but any sort of hearings that take place in court obviously are fair game.
And Your Honor, we would agree. We're talking about extrajudicial statements, and I'm not here, and I want to make it clear, there's no indication whatsoever that Mr. Waters has in any way made any extrajudicial statements prior to today. But anyone that reads this constant churning out there, it would appear somebody is. It's not him. As far as I know, none of his agents. But we want, if that's violated, we'd like to be able to come before the court and have the court inquire how this material fact got out to see if sanctions are necessary. So to be a gag order, it's any extrajudicial statements.
So I have the parties prepare a proposed order that you all have you consented to. Proposed order for me to review regarding the gag order.
I will say this, Your Honor. Obviously, this case, and we all know, we can see what's all around us right now. This case has generated a lot of media attention. And again, the state wants very much this case to be tried fairly and appropriately in a court of law. I will say this, just because information does make it into the media does not mean that it necessarily came from law enforcement or prosecutorial sources. But I think that the state is in general agreement that we want to limit that so that, again, things are handled in front of Your Honor in court.
So we'll prepare a proposed order and try to get to some. I'm sure we get agreement on that, and then submit it to Your Honor, hopefully by late this week, early next week.
All right. Next, regarding sealing of motions.
Not all motions, but any motion which we believe we're discussing evidentiary materials. I mean, typically in a case like this, there'll be some concern about whether or not discovery obligations have been met. And we'd like to be able to not have to detail that in a motion that then is subject to being filed in the clerk of court's office and used by the media to talk about what the facts may or may not be.
I think, Your Honor, if I could, the appropriate way to handle that is that if Mr. Harpootlian or the state files a motion and believes that it should be sealed, that they could file an accompanying motion to seal. And then that would just sort of preemptively seal it until the court could address that order at that
That's
time.
fine.
And
And that's the manner in which it's typically done, a motion and a motion to seal along with the motion.
I don't think we need a global order with that. That
We
can
want
be
an
done,
advance copy
a la
before they
carte.
file it. I mean, they may.
Your Honor, maybe the easiest way to deal with this is if the state, and we'll do the same thing, if the state would agree to give us an advanced copy of something we're getting ready to file, give us the ability to make that motion. And we'll do the same with you. We won't file anything without running it, giving you 48 hours at least, 48 business hours before we file something.
That's fair.
Just want it clearly understood that it's a public matter with a public trial, and certainly the matters that need to be sealed can be sealed to preserve the rights of all parties to a fair and impartial trial. And the court understands that, but at the same time, I want it clear that we will not have any private motion hearings. Public matters will be public.
Yes, sir, Your Honor.
So we'll get your proposed order on that.
Yes, sir.
Can I move on to the next matter?
Yes, sir.
And that is, we filed a motion for speedy trial. We note that there are two terms here, one in October and one in November. And we'd like to go ahead and get this matter before the Colleton County jury as quickly as possible. Mr. Murdaugh does this for a number of reasons. One, as you've heard, he believes he's innocent. He avers he's innocent. And two, he believes that the killer or killers are still at large, and this would allow SWED to put this behind him and go look for the real killers.
Your Honor, the state, as I've already stated, is willing and actually completely agreeable to moving this matter forward expeditiously. I'm hesitant to set a specific term already because there is a very extensive discovery and probably a number of matters that will be needed to address. That could work out. I just think it's a little premature to say definitely that's the term we should schedule it. However, the state is absolutely in favor. The evidence in this case is substantial, and it all points back to Alex Murdaugh. There's forensic evidence as well as all other evidence of his guilt of these murders, and so the state is ready and willing to move this matter forward as expeditiously as could be reasonably done.
And Your Honor, we understand that it's Mr. Waters' belief that there's substantial evidence, both forensic and otherwise. Our response to that is he's wrong, and that's why a jury will sit in that jury box. Was it that jury box? That jury box. One of those, that's the grand jury box? No. Old-timey courthouse, I forget which side we go with. That jury box right there. Hopefully within 90 to 120 days to decide whether that is substantial evidence. Right now, there's an October term with Judge Mullen, and she's recused herself, and November term with Goldsmith, Brooks Goldsmith from Lancaster County. Those are already set. I don't know that we need to get into that today, but we are going to be pressing for a trial as quickly as possible. In that vein, last week we served a discovery motion on the state. They have 30 days under the rules to respond. This matter's been under investigation for a year and a half. It may be extensive, but it ought to be easily accessible, and we ought to be able to get that in 2.5 weeks and begin the process of combing through it ourselves.
We've already provided them substantial discovery in the other matters, and we will certainly comply with our obligations. Your Honor, I think that once we start that process, and I know, and I agree that we need to move this matter forward expeditiously. What I don't want to have happen is for the defense to be screaming speedy trial on one hand and screaming about discovery on the other hand. This is a very aggressive timeline, which we're in favor of, but I think we need to see how things develop and find the most reasonable, expedited term we can. And I think we need to start this process for a few weeks and then make an assessment at that time of what is a reasonable term. That might be January. Obviously, Mr. Senator Harpootlian has his legislative obligations at that time.
Which I will waive.
It seems like probably given the realistic expectations in this matter, that January would be a very aggressive and reasonable timeline.
And we may disagree on that, but Your Honor, I would point out they spent over a year investigating this. They took it to a grand jury. They should have presented them with all the evidence that would have convinced that grand jury beyond a reasonable doubt. And so it's there, it's accessible, you ought to be able, I mean, most of it's electronic, I suspect. They could hit a button and spit it out. we're not going to argue about discovery because I assume they're going to give us everything that would be scientific, everything under Rule 5, everything under Brady, and we're not going to have to fight about it. So we made a motion for speedy trial. I don't know that we need to, until Your Honor decides how to address that, there's no reason for us to draft an order on that. Is that correct?
As far as speedy trial?
Yeah.
I mean, again, I think we need to start the process, Your Honor, and then maybe reassess this matter in a few weeks.
Well, the defendant has a constitutional right to a speedy trial. That being said, however, I am totally unaware of the status of the docket here in Colleton County. I do not know if the Solicitor's Office for this circuit already has day certain trials scheduled or what other matters that currently exist that might be scheduled already or anticipated by, or whether a special term of court might become necessary to try this case.
And Your Honor, we will talk to people. Apparently there's no motion for speedy trial on any case pending in Colleton County right now. So we're the only ones to ask for one, if that makes a difference. And again, we understand it's totally within your discretion, not mine, not his. So we just want you to consider that. And again, I agree with Mr. Waters, it's not something we can rule on today. So thank you for some orders.
Gag order.
Mr. Waters. That resolves everything the defense has for today. Mr. Waters just got additional matter.
Nothing further from the State, Your Honor.
Special Agent Owen, is there anything you would like to state pertaining to the matters here?
No, sir, not at this time.
Any victim input? Anyone wishes to address anything from the victim's perspective today?
We met with them yesterday. I've not been advised of any specific input.
Anything further then?
No, Your Honor, not for the defendant.
None from the State, Your Honor.
All right, the bond will therefore be denied, and matters discussed this morning will be addressed in written orders where necessary.
Thank you, Your Honor.
All right, thank you all.